asking you to do today.
Such Florida, I don't think she is. Chairman.
I think she is when she starts talking about what the Democrats are going to do in Washington, D.C. Okay. So, moving forward, I am concerned it is the role of our state government to be the barrier between the abusive arm of the federal government. And knowing that we have a massive onslaught of gun control laws coming our way, because we've already seen them, we've already started drafting them, some of them have already been presented. I just want it to be as secure as possible and make this wall between our state citizens and the federal government as strong as possible. And so when you use the words lawfully present, understand that what is lawful today in America may not be lawful a month from now, 2 months from now, 3 months from now. What guns you're allowed to carry, how many rounds in your magazine you're allowed to carry. So I'm just asking respectfully that we look at those words lawfully present, because I feel like in the future we may have to change those. And those are mentioned on page 2, line 15, and also on page 10. It's lawfully present. And I think Tim will elaborate on that a little more in a few moments. And then, of course, the last page of this bill is a concern to me. Line 20. I want you to listen carefully to what we're saying. The justification for using physical force or deadly physical force against another person to protect a pregnant woman's unborn child is not available if the first page, it says that we can protect a third party. In Arkansas, if I'm present in a situation and another person in my presence is facing an imminent threat of serious bodily injury or death, in Arkansas, I'm allowed to use my firearm to defend that innocent life. Now, unless I'm wrong, and please correct me if I have misunderstood this, it says that the use of physical force or deadly physical force for protection was used by a person other than the pregnant woman. So I can't protect a pregnant woman, but I can protect any other woman who is in my presence. That I'm just greatly concerned about that, because how am I supposed to know if a woman is pregnant? Other than me, I mean, I was massively pregnant. Everybody could tell, but there are a lot of women out there when they are pregnant, you can't even see. They don't even show, as late as 4, 5, 6 months. And if I use my gun to defend another,
I don't know what the hell is going on now.
Who clearly can't defend herself. If it turns out she's pregnant, it gives an overzealous lawyer a loophole. And I know we're really nitpicking here, but I know how, because I have students who have faced situations like this where the law is nitpicked and 1 or 2 words can actually mean the difference. And so I'm just respectfully requesting that we take a look at this and shore it up just a little bit in a couple of places, and I would be very pleased to stand in bold support of Stand Your Ground. And once again, Senator Ballinger, thank you so much for your efforts on this front. Thank you.
I don't know. It's just nothing's working.
Let's go on to.
I mean, basically nothing's working at all.
We'll take questions. Thank you, Mr. Chair, Senators. My name is Tim Logans. If you're not familiar with me, I'm with the organization known as Gun Owners of Arkansas.
Everything's just frozen. It's locked up. Nothing works. I don't know what to do.
Department of Corrections with 28 years and 1 month. In that former life, I was a SWAT team commander, emergency preparedness coordinator from 2002 until my retirement in 2015. I was an instructor on use of force and trained hundreds and possibly thousands of officers with the department and other law enforcement agencies on use of force.
Okay, yeah, it's just completely.
I was also a defensive tactics instructor. I was also a range master, a chemical agents instructor, less legal instructor, close quarter combat instructor. Was fortunate enough to participate in the World SWAT competition in 2008, the only correctional team ever invited. We placed 13th in the world that year. I was actually deployed to probably maybe less than 500 actual uses of force over my career. More importantly, I wrote the Department of Corrections use of force policy, which was based upon this statute 606 and 607 at the time of my retirement. And was responsible for teaching officers how to stay within the guidelines of the law as it exists. So I'm intimately familiar with 52606 and 52607 as written, and have some knowledge about what the words mean and what they don't mean. And I appreciate y'all for allowing me to participate in this process that is so important to our representative government. Like Ms. Morgan, I stand here today in reluctant opposition to this bill. Even as I say, Senator Ballinger, I appreciate you starting this conversation and bringing this important need to light. And yes, it is a need. The young lady from Philander Smith College made a very important point, and I'm sorry I don't have any notes to go off of it. She was talking about how the general public doesn't understand the law, don't know what it says, don't know what these changes will mean, and it's confusing. And I'm going to say this, Arkansas has a pretty good self-defense law in 606 and 607. That standard of duty to retreat in complete safety is a pretty high standard. With that said, most people in Arkansas don't know what the law is currently. I hear time and time again that I can shoot a trespasser at my home, but in public I must run. Neither of those statements are true. As Senator Ballinger pointed out in his testimony, the real standard is, was the force reasonable? Were you facing a threat? Were you in fear for your life? And was your response proportional and reasonable? Unfortunately, because of words such as in your home and curtilage and duty to retreat, the public is largely confused about what they can and cannot do and what they should and should not do. I will say this, the ability to retreat is irrelevant to a lethal force incident. And that's something that we need to clarify, in my opinion. If I can truly retreat, I am not facing a deadly threat. So, incomplete safety is a very high standard that almost never comes into play, as Senator Ballinger said. I don't know of anyone that's been prosecuted for not retreating, because if you're truly facing a deadly threat, you can't run anyway. You have no choice but to defend your life. My opposition to this bill, and I'll cut to the chase, I've had conversations with many of you here. As Ms. Morgan stated, lawful presence is a very troubling term for me. What is lawful today can be unlawful tomorrow. Specifically, I want to state that this refers to the criminal trespass statute. Now, I saw the memo that Senator Ballinger passed around about the defense of this bill, and said, yes, trespassers would have to retreat. And I think his assessment was correct in that. The problem is when are you trespassing? For instance, if I am a otherwise lawful citizen that is constitutionally carrying, as many of you know, no permit is required in Arkansas to carry a weapon. And if I go into a location that has a no gun sign on the door, if I didn't see it, by the trespass law, I could potentially be trespassing, because trespass law says entering unlawfully or remaining. Now, law enforcement has typically not cited or arrested anyone unless they refuse to leave. But the statute says or, not and. So if I'm an otherwise law-abiding citizen that is faced with a deadly encounter, and it's later revealed that I went past a no-gun sign, it could be determined very easily by prosecutors that I was not lawfully present. And therefore, by removing incomplete safety from the current statute, I now have a duty to retreat, which is a scary option for me. Because what we're doing is confusing citizens and dividing them based upon class and money. And when they don't know if they're there lawfully, many of us can trespass or otherwise be unlawful and not be aware of it. I'll give you an instance that will bring this point home. A friend of mine in Jonesboro was recently detained at the Embassy Suites at Arkansas State University. He was at a business meeting. That's the day the governor was there, by the way. I don't know if any of y'all attended that or not. He had a business meeting not related to the governor being there. During the course of his meeting at the Embassy Suites Hotel, one of the businessmen he was meeting with said, hey, I need to step outside and take a break and smoke a cigarette. My friend stepped outside with him to smoke a cigarette and continue the business meeting, and he was detained by the campus police of Arkansas State University because he was carrying a weapon. Now, the controversy in question comes into play. Was he on hotel property in their parking lot, or since it is built upon Arkansas State University property, was he in violation of 573-119, carrying a weapon without a enhanced carry permit as described in 573-322? Well, I'll tell you the outcome of it. He was detained for 2 hours. His concealed handgun carry license was pulled, and it was recommended that he face felony charges. simply for having a weapon in a hotel parking lot. Now, I want to go further with this scenario. If at some point during his stay at that hotel, he had been assaulted, or if he had saw someone that was being assaulted with a deadly threat, and he had intervened and used his weapon, by the very definition of the actions of the campus police, he would have not been lawfully present, and he would have had a duty to retreat and not be able to defend himself. And why that's so important, by removing incomplete safety from the statute, as Senator Ballinger has done in 607, the only thing that matters is you have no duty to retreat if you meet conditions 1, 2, 3, 4, 5, and 6, number 1 being lawfully present, which means since incomplete safety is removed, if you don't meet any one of those 6 criteria, you now have a duty to retreat, which also means that you must proactively show the prosecutor that you attempted to retreat or why you could not before you can claim the privilege of the statute. That's very concerning to me. Now, you're going to say, Mr. Loggins, do you know of any cases where this has happened? Do we really want citizens to face this potential next year, 2 years down the road, 3 years down the road, where because their lawful or unlawful presence is what's determining was the force justified or needed, instead of was their response reasonable and did they fear for their life? I do appreciate, Senator, the change to number 4. That was also a concern for our organization. I think that clarified the law a great deal, and what you meant and intended is now very clear, and I appreciate that change. As Ms. Morgan said, we also have an issue with page 4, where we remove the ability of another person to defend the unborn child of a pregnant mother. I know Arkansas is one of the most pro-life states in the country, a fact that I'm pretty proud of. To me, this is reducing the value of that child's life. Ms. Morgan stated that we had the ability to defend the mother if she's being attacked, but we've removed that child as a person that I'm capable of defending. What if the mother cannot? What if the mother isn't armed? I said, now I'm going to have to show prosecutors that I was defending the mother's life and not the unborn baby's life. That's troubling, and I'm not sure why we're doing that. My final concern would be
why. It
on
just randomly cut me out.
the recommended amendments that Senator Ballinger has introduced. Currently under Arkansas 52606, there is no mention of duty to retreat. There are no qualifiers under which you must do anything. Now, there are some qualifiers that says the force is justified or not, such as you're not provoking, and he covered those, and he's correct on that. But currently in 606, there is zero duty to retreat, zero. And now we have made the ability to defend ourselves against non-deadly force more restrictive, I'm afraid. Now, he's correct that it refers to 52607 and says you may not use deadly force except as provided in 52607. He's correct in that. But 52607 says you have a duty to retreat if you can do so in complete safety. So right now, there is zero verbiage mentioning duty to retreat in 606, and I'm not sure how we're helping our citizens know when and when they cannot use force to defend themselves by inserting it in that statute. I appreciate the committee's time, and if I'd be happy to answer any questions. Senator Flowers, you're recognized.
I just have one question. So you're suggesting that the criteria that the Prosecutors Association has supports in here in terms of when a person is not required to retreat before using deadly force, these 6 factors, are you suggesting that a business that posts a sign that says no weapons allowed on the premises does not have the right to do that? And wouldn't that be unlawful presence if you did appear at that premise, that business premise, with a weapon?
Thank you, Senator, for the question. And yes, ma'am, I agree. And I defend the right of a property owner to decide who gets to carry a weapon and who does not. I'm not in any way saying that someone should ignore a business's wishes. But I know
well, but isn't that lawful present at the location violated when you come with a gun where it's posted?
It is possible to bypass a no gun sign without being aware of it. I've done that myself unintentionally. The location of the no gun sign is inconspicuous. I was unaware that property, the example I used with my friend at ASU Jonesboro Embassy Suites, he had a concealed carry permit and thought he was on hotel property. As it turned out, he was on ASU property. He was not in felony possession, although technically he was, but it certainly wasn't his intention. Because he was on the college property, he was in felony possession of a weapon for violating 573-119. Now, the issue comes that I have a problem with is I'm in no way encouraging anyone to trespass. I'm not encouraging that, and I believe absolutely my gun rights do not trump a business owner's rights to post no weapons. The problem is whenever a citizen, through no fault of their own, unknowingly is now in a location that makes them unlawful, we are saying that they must retreat and they've lost their right to defend themselves. That's extremely troubling to me. My right comes from God to defend myself and should not be dependent upon a statute saying anything about where I'm at.
Well, my point is that a property owner, if they post a sign in the law, I believe that we sat up here and passed a few sessions ago, said specifically how conspicuous the sign must be at a business premise. And if somebody tells you and you come on into their residential property or the curtilage that I don't want you with your gun, some people know. And the point is this too. I think what you all both are saying is
we still have
how
a guilty
people can be ignorant of the facts that are present in the environment. And it speaks to, you talked about all the training that you've had.
No offense, but
Law enforcement has
we
training.
still have a guilty.
People that have deadly weapons ought to have training, is my opinion. Thank you very much, Mr. Chair.
If I could respond very briefly, Mr. Chair.
We still have a.
We're in agreement on the property rights of the individual, Senator. I in no way am encouraging anyone to violate a property owner's rights. Now, as far as last session passing a law saying it must be conspicuous, actually when we passed 573-322, it no longer requires signage, just the business owner's desire. So they don't have to have a sign to say, hey, you've got a weapon, leave my property. And I think that is an improvement, by the way, because my gun rights do not trump a property owner's rights to have someone there under what conditions they choose. But a conspicuous sign is no longer necessary, just the owner's wishes is what's necessary under current statute. Senator Ballard, you're recognized.
Thank you, Mr. Chair. I just want, the previous individual who testified, she did a great job and she made a good point, and you reiterated that sometimes language is hard to read, and in particular, somebody who's not been involved in the bill process sometimes doesn't understand the bill process. And so I'll just ask you, if you'll look on page 4, either one of y'all can do this. Page 4 in line 23. The section that you all are concerned about in the ability to for a person to protect an unborn child is that section on line 23 and 24, is that underlined?
Number 23 is not, Senator.
Okay.
24 is actually crossed out. So the defense of defending the unborn child by another person has now been made zero.
So let me see that the defense is there. So 23, this language that you guys are concerned about is there. Over here, when you get down to 25, down to 30, that's the exception. So that's the language that would require her to retreat if she could retreat safely. That's what that is this is pointing to the code section that frankly is gone now because we've removed it. Now, I would agree that an unborn baby is a person and that you should have the ability to protect that person just as like you would any other person. However, that language that is addressing that's previous. In fact, it's I think Senator Stubblefield and I carried that bill. Back then, that was the best that we could do. Maybe we should go further and fix that, but that language there in this section is not being changed.
Can I respond, Mr. Chair. I'm somewhat familiar with the bill writing process and the lawmaking process. It says the justification for using physical force or deadly physical force against another person to protect a pregnant woman's unborn child is not available if. Okay, and the condition that is still remaining in your SB24 is it is not available if the use of the physical force or deadly physical force for protection was used by a person other than the pregnant woman. Now,
So, correct, but that's not underlined, right?
That is current language.
Current language.
And my point being, whenever you struck out the next section, which starts at line 25 and going forward, you removed another person's ability to defend an unborn child.
No, because that is another exception. So what we've done here, and I get that you're saying that the bill doesn't go far enough and that there's other things that I get it. Like, I would probably agree that it would be nice if it went further. However, what you're talking about is the current state of the law is not what we've done with the next section we've taken out another exception.
Well, what you've taken out is the reference to 52607, which is our current deadly force law. So whenever you say is not allowed if it's another person, and then the part you took out, except as under 52607. So what you're saying is under 52607 currently in this statute that you're amending 52615, what you're saying is you're removing my ability as a third person that was justified previously under 52607 exception. That's my reading.
And I this is a great illustration of how sometimes this stuff is. I wish there were a better way to do it. It can be confusing, but the important thing to do is we're talking about exceptions. This is when it's not allowed, right? And so that is saying in this situation, it's not allowed. The inability to now, obviously, and let me say this, one thing that you said that I think is, you can still protect the woman, right? So
but not the unborn child.
Not the unborn child, that's right. And so there's a gap, there's a hole in our Arkansas code, clearly, that should be addressed by sometime, and probably should happen this session, right, to be able to protect an unborn baby. But guess what? There's also 100 other ones. In fact, let me say this, within gun laws in the state of Arkansas, there's 100 other ones that need to be addressed, right? But this bill doesn't do that, right? This bill is only dealing with the duty to retreat, and that's what we're dealing with in the other section. So I don't blame you, other than the fact I have addressed this with several of you guys to get it cleared up before, but I don't blame you for not understanding it. But that's what it is that you're misreading the code section. You're right that there is a limitation on ability of another person to protect the unborn baby, but it's not in this bill. That's in the code already. We just haven't addressed it in this bill. Right?
Unfortunately, Senator, I understand everything you're telling me, and I believe that current statute allows better protection of the unborn child than removing this language. Now, I understand I can still defend the mother. I'm just worried the message that striking that language is sending, and I still have the ability to defend the mother, but I worry about that language.
The language is an exception. You would agree with that, right?
I would, yes.
So we are striking an exception to that defense, correct?
The exception being the reference to 52607. And, Mr. Chair, if you please, I would ask one thing, the language of lawfully present, I would be able to support this bill completely if we could change that to right to be there, or some other verbiage that wasn't dependent upon what a statute is, or what this body, the governor, a president, a United States Congress, lawful changes from depending upon who's in charge, who's in power, and day-to-day activities of the legislature. My rights never change. My rights come from God. And I would ask that the committee consider looking at that change in the language, simply because we don't know what tomorrow brings. We don't know what's going to happen down the road from this body, from the next body. As Ms. Morgan said, whoever's in charge or authority can change lawful presence, and that's just very troubling to me. Senator Johnson.
Senator Bellinger, I wish you would address, I just want some clarity, okay? And about this, duty retreat, and I've discussed with Tim about the complete retreat, and if Senator Ballinger would discuss that, when that was put in the code and how it already exists in that common defense, if you would please, and that might get clarity on that one there.
Yes, Senator Johnson, if I could, before he does that, I think this may help clear things up, and then we'll ask Senator Ballinger, to answer your question. This lawfully present in the location has been one of the things that's been on page 2, line 15. Has been one of the things that has been presented to me as a problem. And Ms. Morgan, I think you pointed out in your testimony that while that was a problem, that was in many laws in other states. And to my surprise, as I studied Florida in depth into the wee hours of the morning, because everybody was pointing to Florida, to my surprise, since they kicked all this off, the prosecutors there used those exact words. So it must be in the law there, lawfully present in the location. So y'all are aware that in the Florida law that it's there, lawfully present in the location.
Can I answer, Mr. Chair?
And again, I very much understand your objection, Mr. Loggins,
Yes.
and I'm sympathetic to it. But you do understand that it is in the Florida law.
My answer would be that Florida is a permitted state where you have to have a permit to carry a weapon, as opposed to Arkansas and 15 other states that are constitutional carry with no permit being required. So I understand that lawful in Florida doesn't mean the same thing as lawful in Arkansas. That's my concern.
Okay. And we also understand the difference between good and perfect and being able to take a step. But Senator Ballinger, if you could answer Senator Johnson's question.
I think it'd be better to fix this now.
Yeah, thank you very much.
I think it'd
appreciate
be simpler than that.
the forbearance and leeway. So going back to ancient common law, the right of self-defense, right? It's been changed by code through the years. In general, it's a question of reasonableness and whether the force matched the threat. And so the question of whether or not you can retreat and the issue of complete safety, that's something that was added to the code that was negotiated. It was an effort, I think, more than anything, to get us to move from being a non-stand your ground state to a stand your ground state. That language was put in. However, the very nature of the defense of self-defense is you never lose it, right? So the only way that you have an obligation to retreat is if you can retreat in complete safety. So because you don't lose that right of self-defense. So if you cannot retreat in complete safety, you cannot retreat. You still retain the right of self-defense no matter where you're at. So that language is great. I'm better than not having it in there. However, that's how it's being interpreted anyway. So with or without that language, the question is not whether or not it's a possibility you could retreat. The question is whether or not you could retreat safely. And so it almost is irrelevant whether that language is in there or not.
Mr. Chair, could I respond briefly? I do have a point.
I appreciate it. If a member wants you to, because that question was from Senator Johnson to Senator Ballinger. So if any one of them asks for you to, you can. Otherwise, no. Senator Johnson. Senator Johnson's pitching it to you, Mr. Loggins.
My only question, Senator Ballinger, is I understand the reference to common law, and when we're talking about common law, we're actually talking about Blackstone and commentaries and the 3 divisions of homicide that Blackstone made, ranging from one is felonious assault and it being necessary and mandatory, and then you get all the way down to trial by combat, where you got mutual combatants that are engaged, and then you have a duty to retreat. That's where Blackstone first mentioned duty to retreat. So under common law, the only time that, even in 17th century England, I think you would agree, the only time that even 17th century England had a duty to retreat was whenever they were in mutual combat by agreement that rose to the level of a lethal encounter. So I know this is quibbling and we're talking about a lot of stuff that people are going to say, well, what are they even talking about? But the point I'm trying to make is under common law, there is no duty to retreat except under very specific circumstances. Now, we've taken that and translated it over the years to a castle doctrine, to a right to stand your ground, to all sorts of things that really don't apply to common law as written in
That ate
Blackstone.
up a lot of time.
And that was my point. Thank you, Mr. Chairman.
It wouldn't let me log in, then it froze,
Okay.
then I had to.
Any other questions for these witnesses? If not, thank y'all for being here. Committee. The Senate meets at 1. It is 12:18. We have 5 more people signed up to speak. What's your pleasure?
Motion for immediate consideration.
I have a motion for immediate consideration from Senator Garner. Does that take a second? Does not take a second. All for the, and there's no discussion, all for the motion signify by saying aye. All opposed? Here, none, motion is carried. So we will now vote, and because we had motion for immediate consideration, there is no discussion on the bill. We are voting to whether to pass out of committee Senate Bill 24 as amended, SB24.
Well, somebody has to make the motion, to pass as amended.
But
A motion do pass as amended.
motion do pass as amended. And a second from Senator Johnson. All for the motions to pass SB 24 as amended, signify by saying aye. Aye. All opposed? No. Motion carried. Senator Flowers asked for a roll call. And remind everybody of the rules, since it's early in the session, it takes 1 member to ask for a roll call.
Senator Hendren? Senator Hendren votes no. Senator Stubblefield? Senator Stubblefield votes yes. Senator Rice? Senator Rice votes yes. Senator Blake Johnson? Senator Blake Johnson votes yes. Senator Garner?
Yes.
Senator Garner votes yes. Senator Ballinger? Senator Ballinger votes yes. Senator Flowers? No. Senator Flowers votes no.
The SB 24 carries with the vote of 5-2. Senator Ballinger, you have passed your bill. We have no more business today. Meeting is adjourned.